Hi, good afternoon, everyone. Thank you for joining us for this session on mediation right after lunch. I hope we've got a diverse group of persons here that would shed some light on mediation. Let me first introduce myself. I'm Anthony Lee. I'm a director at the SIMC. Before I joined SIMC, I was a general counsel in the financial services industry for about 19 years, and before that I was in practice, both as a litigation lawyer as well as a transaction lawyer. I'm also a mediator, paneled with SMC and SIMC, and I think that time, the training I had as a mediator certainly helped me when I was a general counsel in-house, as many of you are, where you take all those skills and as a trusted advisor to so many people, solve many problems which are never yours to start with. But that was one of the great gifts that my previous employers gave me, was to allow me the opportunity to train to be a mediator. And that's one reason why I think this session is particularly special for me. Just a little bit of housekeeping. If you have any questions, please feel free to sort of like put this on take this slide, use this QR code and put your questions on the Slido. Alternatively, feel free just to put up your hands and ask any questions that you may wish to have. We're very fortunate today to have a very distinguished and mixed panel of speakers from mediators to lawyers to persons within the SIMC, very much in the system. I'm not going to introduce them individually, and I'll start with Bennett, my colleague from SIMC. Bennett is the registrar of SIMC, and he's going to kick us off with just putting some base levels of what is mediation, how it works, and what works well, what are the and all its benefits. So I hand it over to Bennett. Thank you.
Okay. As the registrar, I see a lot of cases, and through the years doing this, I've been here for about 3 years now, and after administrating so many cases, I've seen certain trends and certain misconceptions which I want to share with you. And there are certain things which mediation can do, which litigation and arbitration cannot help you with. Okay, so I want to start off simply with 5 unique characteristics of mediation, which is not commonly known to everybody. Okay, so first let me just start with the first unique characteristic. It is quick. You can do it anytime, anywhere, and the cost is within the party's control. Now, when I talk about quick, there are 2 aspects to this. First is that you can arrange a mediation very quickly. Okay. Ideally, the runway should be about a month, but at SIMC we have done it in 4 business days. Okay, it can be done, not advisable, but it can be done. Okay. So the parties have to be kind of really rigorous in their deadlines, but we have done it before, over Chinese New Year in fact. So there's one case. So it's also quick in the sense that unlike arbitrations or litigation, I would say 98% of our mediations last only 1 day. Now 1 day is probably very surprising to most of you who are not familiar with mediation, but within a day you can either get it settled or you will kind of know whether there's a chance of settlement. So if by the end of the day, the mediator feels that there is parties are still very far apart, then he'll just probably call the mediation to a close so that you don't waste any more time. Parties can pursue arbitration or litigation. So it's quick. Anytime, again, there are 2 aspects to this, right? Anytime means we've got cases filed for mediation before litigation arbitration has commenced. There are also cases where mediation is requested after litigation or arbitration has commenced, so it can be any time during that process. Any time can also mean it can be any time of the day, So for instance, if you are in a litigation, you don't expect the court to be open in the middle of the night, but mediation is very flexible. It can accommodate people whose time differences can be like 12 hours or more than that apart, okay? So anywhere, again, is unique to mediation because you cannot choose your court, or sometimes even your jurisdiction for the arbitration, because in mediation there's no jurisdiction issue. You choose where you want to go for mediation. So that's one. It can be anywhere also because you can hold it in a venue that is dedicated for mediations, like what we have in Singapore, Maxwell Chambers, or you can hold it in a hotel or in a lawyer's office. And we also say you can hold it in even in a seaside resort where we always say the settlement rate will probably be higher because most of the parties don't want to be stuck in a room when there's an inviting beach and a deck chair outside, right? So it can be anywhere. And finally, because it is so quick and because it's usually a day, and parties can choose the medium, anytime can also mean online. So you don't have to, anywhere can mean online, you don't have to pick a physical venue. So it's very flexible. So because of all these parameters that are within the control of the parties, they can actually control their cost, the cost of mediation, okay? So this is something that is very important to parties especially because cost comes in various forms, right? It's not just about the expense, financial expense. Cost also means the time spent preparing for litigation or arbitration. And it also is an expense on management focus and time. So because of this, you can control the cost, and in the middle of the mediation, one party can always walk out if they are not happy with what's going on, how it's progressing, with no adverse implications of cost, because it's all consensual. There's no one is forced to attend mediation. Now the second very important distinction of mediation compared to arbitration and litigation is that you are in control of the outcome. Parties are in control of the outcome. There are no unacceptable outcomes. Because the mediator has no power to impose anything on any of the parties. In an arbitration or a litigation, one party is going to come out feeling really sore because it didn't go the way that the party wanted. But in mediation, parties settle only because they want to settle. The mediator cannot force them to settle. And even if there's a settlement, the terms of settlement are agreed upon by the parties themselves. It's not mandated by the mediator. So you have control over the outcome, and it's not confined to legal solutions and processes, right? So for instance, you're not confined to just damages. Sometimes mediation could be addressing hurt feelings, can even be just an apology, right? There are cases where contracts were terminated and revived. There were even cases where as part of the settlement, an agreement is entered into by parties that are not even relevant to the litigator, to the mediation. It could be with a subsidiary or fellow affiliate, entered into another contract. There have been cases where parties have settled because they have handed something from one party over to the other that is tangible, that is worth something to the other party, but there's no financial value to it or price that you can ascertain to it. So these things can bridge the gap between the value that one party is expecting from them. So there are various ways. Non-confined to legal solutions, we also seen cases where the patent infringement or trademark infringement case where the trademark owner, as part of the settlement, agreed with the infringer to collaborate to go after other infringers. So from enemies, it became allies, right? So these are things you will not see in a litigation or an arbitration. So like I said, it is collaborative and forward-looking. It's different from arbitration or litigation where the court or the arbitrator is trying to determine who is right and who is wrong based on what has already happened. Okay? Mediation, on the other hand, is looking at which is the best way forward for all the parties, despite what has already happened. Okay? So it's forward-looking. It's not there to prove who is right and who is wrong. I mean, you could be right, but do you want to wait 5 years to prove that you're right? And then thereafter, another 2 years maybe on appeal. So you eventually get what you prove yourself right, but how much have you spent in the process? How much time have you wasted? And finally, there are less enforcement issues. Why? Again, it's because the parties agreed to the settlement agreement without coercion. It was not imposed on one of the parties. And so you find that they have already agreed that this is the best way forward for both of them, and therefore they're more than happy to comply. And in the case of arbitration and litigation, one party is not happy with the outcome, and so you need to enforce it against the other party. And I also was told that in an arbitration where you have an award against a state, it is not easy to enforce. Okay? So these are some of the, I would say, the 5 unique characteristics of mediation which distinguishes it from litigation and arbitration. Now, because of these unique characteristics, we are seeing certain kinds of cases more and more over the past few years. We still get the majority of the bread and butter kind of disputes where shareholders disputes, a sale of goods, delivery issues. But you see that one of the kinds of cases you are seeing more and more of are professional negligence cases, for obvious reasons, right? I mean, we've seen cases coming for mediation involving lawyers, involving doctors, involving fund managers, involving private bankers, investment advisors, just to name it, even architects, right? So obviously they don't want this to get out to the public, they want to settle it quickly, and they have really better things to do than to deal with this, so they try to get this resolved as quickly as possible. The other one is employment. Of course, nobody wants, excuse me.
Can I answer a question on professional negligence? My name is Foley. So what's the general receptiveness of PII insurers towards mediation? I mean, I'm guessing most of the professional negligence cases, the parties will have some form of PII cover, right?
Yes,
are the
yes.
insurers receptive to this, or?
Yes, they generally are, and they will always be kept in the loop. It's not like you settle and then you go and tell your PII. The PII people will already be in the loop as to what are the settlement, what are the parameters of settlement before they come for mediation. So employment, again, is very obvious. No big company that's well known in the world wants to know that their employee is suing them for something, right? And the employee themselves also don't want to drag this on because they don't have as deep a pocket as the company, and they also have new jobs to go to, and they don't want to have this hanging over their heads. Then the family businesses. Okay, we have cases where some families are so well known in certain countries, they would rather not be seen having a dispute in their own country, so they may just come to a non-neutral country to mediate, even though they are family members. And it's quite obvious, because family members, they also want to try and preserve the relationship between themselves. And mediation, because it's collaborative, is less confrontational, it's not so antagonistic. So in many cases we have managed, the parties have managed to salvage their relationship and carry on business. We are also seeing more private versus state agency cases. This is interesting also because I think most governments also do not want to be seen litigating in public, especially if you're dealing with a foreign entity that has come to invest in your country or has been engaged to build, say, an infrastructure project on behalf of the state. So surprisingly, actually the success rate in this category is even higher than the average that we've seen. So I think it's all because of the fact that states also don't want to be seen suing the contractor or whatever, and the contractor also don't want to offend the state. They try to find something that is mutually acceptable. And finally, of late, we've seen more crypto asset disputes coming from mediation in all kinds of areas of crypto assets. So it's not just failure to deliver bitcoins. It can be relating to platforms, trading exchanges and all that. Issue of coins that became worthless, right? So it's quite obvious because crypto assets, the price of crypto assets change very quickly, and most parties want to get it resolved, the dispute resolved as soon as possible. So what are the common misconceptions of mediation? I'll just give you 5 and I'll stop there. The first is that mediation is pointless if parties have really been negotiating directly for some time without success. So lawyers may suggest to parties to mediate. They say, what's the point? I've been talking to this guy on the other side for the last 1.5 years and we're getting nowhere, right? But they don't realize that in mediation, there is a middleman called the mediator who is able to draw the parties together. And how does he do that? It's because there may be information that one party may be prepared to share with the mediator, but not prepared to share with the other party. And that's confidential to the mediator. But the mediator then knows where each party is coming from and can draw the parties together. So it's not the same as negotiating directly with each other. A second common misconception is that a mediator's expertise in the technical aspects of the subject matter of the dispute should be the primary consideration in the choice of the mediator. Okay, so many times they will say, oh, this is a construction dispute, so I want somebody who's an expert in construction law or a certain aspect of construction law. You may have somebody who's an expert in construction law, but he may be a very poor mediator. So I think the first thing you need to look for is a good mediator. And then the technical aspects, usually the parties are not having a dispute over, they can always advise the mediator. Okay? So, because mediation is a skill, it's not about who is right and who's wrong, it's about what is the underlying cause of the dispute and how to reconcile the interests of both parties. Right? In the worst case scenario, sometimes we will have two mediators, one experienced senior mediator skilled in mediation and another co-mediator who is expert in the area under dispute. But of course, the cost of mediation will be higher in that kind of situation. The third thing is that third misconception that is the party's primary interest is to have their perceived legal rights reflected in the settlement terms. Now, I'd like to give an example of one case because lawyers tend to think that legal rights are paramount and therefore we should push for the legal rights, and if you don't get the legal rights enshrined in the settlement agreements, then they have not done their job. Okay? I'd like to give the example of a case where one of the parties sold the business to another party, and there was some problems with the business, and so the owner of the new business sued the seller of the business, and he sold, of course, at a very good price. I mean, we're talking about multi-million-dollar deal, right? And of course, they came for mediation, and the seller then wanted to settle at a certain price, which was acceptable to him. But the lawyer next to him kept telling him that you shouldn't settle at this price. You can do better. You can go to court and get a better deal. And in front of everybody in the mediation room, the client told the lawyer, I know you're a very good lawyer. I know you have my interests at heart and everything, but I just want to wake up with a peace of mind tomorrow. You know, I'm prepared to pay for this, and seriously, it was just a drop in the bucket from what he had already collected. So it was not a big deal to him. So I think lawyers need to understand that you need to look at your client's interests because it's not every time about enforcing legal rights. Sometimes it's just peace of mind. What is fair to the parties is what is fair and in the interest of the parties, regardless of all your personal views. Another misconception is if there's no final settlement of the mediation resulting, the whole dispute, the mediation will be a failure. Okay, that's again not true because there are various benefits of mediation. First, sometimes the mediation may not resolve the whole dispute, but it can resolve some of the issues. In which case, you only litigate and arbitrate on the remaining issues, which saves you time and money. And there are also many cases where after the mediation has concluded, although there's no settlement agreement, parties now understand each other's perspectives better and what is withholding the other party from agreeing to a settlement. And we've seen many cases where after the mediation is settled, over the next few weeks or sometimes even months, and in one case a few years, where the mediator kept following up, a settlement was actually reached. So it kind of opens up the communication between the parties after mediation to further discussion. Sometimes it takes 2 or 3 sessions of mediation. Sometimes it's through private negotiations after mediation. But we do follow up to see what's going on. And we are quite happy when we see the parties have managed to settle after the formal mediation because the channels of communication were open. Because in most disputes, you sometimes see one party, you don't even see the other party, there's one institution against the other. So like, I would like to give the example of a case where a patient died and they sued the hospital, right? And during the mediation, of course, the party that lost the loved one is very aggrieved and outside the mediation. But when they saw the doctors and administrators or hospital people at the mediation and the nurses who cared for this person, they were also in tears at the mediation. And they realized that, it's not, they also suffered. It was not that, it's not their family, but they still suffered. Doctors were in tears, the nurses were in tears. Did they settle? Not at the first instance, but from my follow-up and checking, they eventually settled. So there was this communication that was open. Because to the patient's family, it's just a hospital. It's just an institution. But when they see the doctors and nurses involved and the emotions that they portray, and these are not actors, right? They realize that it was not they who suffered alone. Doctors and nurses also went through a difficult period because of this. And finally, then another big misconception is that enforcing a settlement agreement is a major issue. Again, I said it's not, because parties agreed to the settlement agreement, unlike an arbitration award or a judgment, and therefore you don't have these big issues of settlement. In fact, we have not seen any enforcement issues so far. The only time they come back after they have signed a settlement agreement is because there was some ambiguity in the settlement agreement that they want clarified. So we have not seen any enforcement issues so far as we know from the cases that we have handled. Okay, I think that's all I have. You can take questions if any.
Thank you, Bennett. And I hope it gives everyone an idea of what mediation is and what it can do. I think it's an important baseline for everyone to have, because there are many misconceptions.
Question?
Yes.
Just have a quick question for Bennett. Say in this context, it's a professional negligence case, and you have been tasked to basically convince either side to go for mediation. And in the professional negligence cases, often there's a lot of pride and ego, because it's about their work that they do, right? Everyone has a view about that. My specific question is that, how can a mediator sort of cut through the ego, because that ego is the only issue, in my view, that is stopping the parties from trying to even talk. Yeah. So how, convince me how do you cut through the ego?
I think the best person to answer you will be a mediator like Francis.
Yeah.
Francis, I told you to come with your direction.
Thank you.
Yeah.
Thank you for the question. You are right. Emotions play a big part in any mediation. You can put the most rational professionals in the room, but when you are questioning their integrity, their professionalism, saying they are wrong, you can expect all the heckles to come up. So a mediator is that neutral third person that helps to get the perspectives from both sides. And mediator is trained to manage people, manage emotions, and you just have to allow the process to unfold. And I've handled professional negligence cases in the course of my work, and I find that invariably people just want to be heard. People want to be able to tell their story in a safe space, and when that is all out, then they are in a position to be rational. And that's where the professional indemnity insurance people would help by, saying what is acceptable, not acceptable, but the parties needed to get it off their chest. I hope that answers your question.
Yeah, that is quite consistent with my experience. Unfortunately, as advisors to parties in dispute, we are not best placed to break that barrier, because if you do that, then they say you're not on my side, right? So we need someone like you.
And that's why Bennett says it's important to have someone like a mediator who can be that, rational voice, third person in the room.
Thank you.
Keep the questions in your mind or put it in the Slido. In the meantime, I'm just going to move the conversation on to Maria Gotzeritze. I hope I've got that one right, Maria. Mariam's a principal research fellow at the Singapore International Dispute Resolution Academy, and she's been part of a study on dispute resolution. I'll let her tell you more about it and what the findings are. Mariam.
Thank you, Anthony, and thank you for having me. Can we have the presentation? Okay, perfect. So first, let me briefly tell you about SIDRA International Dispute Resolution Survey, and then I will give you the most important findings from our 2024 SIDRA survey. Of course, focusing on international commercial mediation, given the topic of our panel today. So, SIDRA survey was launched in 2019, and it had been conducted once in every 2 years since then. We have completed 3 iterations of SIDRA survey. What distinguishes our survey from other surveys in the field is its main features. First of all, it's 100% user-centric. Our respondents are actual users of the international dispute resolution mechanisms, and they are identified as external counsel or in-house counsel and corporate executives. Secondly, we ask users to respond to the questions based on their actual experience and not just their preferences. Then we only cover international dispute resolution, cross-border disputes. We don't cover domestic dispute resolution. Our survey is internationally distributed in all 6 UN languages, which is English, Chinese, Arabic, Russian, Spanish, and French. And finally, we don't examine any dispute resolution mechanism in isolation. We believe that developments in one area of dispute resolution can have impact on other areas. For example, if we consider current interest towards mediation in investor-state dispute resolution as a response to the criticism towards the system, or increased use of mixed mode dispute resolution, which involves mediation and other formal procedures like arbitration or litigation. Our respondents come from various jurisdictions. Number of respondents varies from survey to survey. For 2024 survey, we had 211 respondents from 25 jurisdictions. Mainly these are Asian jurisdictions, Asian countries like Singapore, Indonesia, Philippines, Malaysia, but we also had quite significant number from UK and other countries. In 2024, 90% of our respondents were external counsel. Unfortunately, in-house counsel and corporate executives only 10%, and we hope that with your help we can improve these numbers for 2025 survey. So, in terms of the findings from 2024 SIDRA survey, let me first give you a perspective on comparative analysis of respondents' expectations and satisfaction across various dispute resolution mechanisms. So we asked respondents to identify factors that are absolutely crucial or important when they decide whether to mediate, litigate, or arbitrate their disputes. So the factors like speed and impartiality were most important factors across all 3 mechanisms, but then other factors, the results varied. For example, confidentiality was considered more important in arbitration and litigation than in mediation, but factors like preservation of business relationships or indirect cost to client business, which is mainly reputational cost, was considered more important in mediation than in litigation and arbitration. We believe these findings express main features of the 3 dispute resolution mechanisms. When it comes to actual experience, our respondents were satisfied with factors like direct enforceability, finality, and impartiality across 3 dispute resolution mechanisms. But then other factors, for example, respondents recorded extremely high satisfaction with cost and speed in mediation, and very low satisfaction with cost and speed in arbitration or litigation. So this concurs with something that Bennett has mentioned, that mediation is more cost effective and speedy compared to arbitration and litigation. Same goes for preservation of business relationships and indirect cost to client business. Respondents were highly content with these factors in mediation compared to litigation and arbitration. Now specifically regarding international commercial mediation, how is mediation triggered in practice? According to our respondents, the most common basis is external counsel advice, followed by contractual obligations and then client requests. So these findings highlight the importance of external counsel advice, and this might be the reason why in many jurisdictions it is a duty of lawyers to advise clients to consider mediation or other ADR mechanisms for that matter. And this is the case in Singapore, in Australia, and Hong Kong, also in Europe, for example, in Italy. I should also highlight that the role of in-house counsel advice was only 29%, which I think is a bit regrettable, and this is something probably to consider going forward. So, in terms of choosing mediation, factors that parties consider when they decide to mediate their dispute is cost and speed again, and then impartiality. In terms of actual satisfaction, users were satisfied with all the mentioned factors, and in addition they were highly satisfied with confidentiality and procedural flexibility. And when it comes to speed and confidentiality, number of satisfied respondents was higher than the number of respondents who considered these factors important. So it means that their actual experience superseded their expectations in practice. And then finally, choosing mediation institute. When deciding which mediation institution to use for administering their mediation, parties consider factors such as efficiency, cultural familiarity of the panel of mediators, and also the quality of services in administering mediation. In terms of actual experience, users are quite satisfied with all these factors, and they are also quite content with panel of mediators and costs in mediation. Cost of administering mediation by the institution. We also asked our users, our respondents, to name the most used mediation institution. We gave them a long list of institutions, and we offered also the possibility to name any other institutions that they have used and had positive experience with. So the most used mediation institution, according to our respondents, is Singapore International Mediation Center, followed by other institutions, and also ICC Mediation in Paris. Finally, before I conclude, I would like to let you know that in January 2025, we launched fourth iteration of SIDRA's survey. It is currently open for contributions. It takes 15 to 20 minutes to conclude, and it's completely anonymous and confidential. We would be very grateful if you could participate and share your experience with us. After we collect the data, we will issue final report that will map developments in international dispute resolution. Thank you very much.
The SIDRA report is available on our website, so you can get a copy of it on the website. It covers not just mediation, covers arbitration and litigation as well, but we're just focusing on mediation part of the report.
The QR code will take you to the website.
Thank you, Miriam. I hope that sort of like gives all of you at least an idea of the global, maybe regional trends in dispute resolution. I felt it was important that Mariam sort of shared these perspectives, because as senior lawyers, I think it's important for you also to sort of like horizon scan, see what are the trends coming, understand why the trends are there, I think it reaffirmed what Bennett said earlier about some of the benefits of mediation, the speed, the flexibility, the ability to maintain relationships. And I think the survey, which is actually done by a majority of external lawyers, right, bears some interesting reading. And I'm speaking now a little bit longer because I'm keeping the QR code there a little bit longer as well. Because I think it's important that two things I think that are important to call out. I think the first one is for in-house counsel to participate in the survey, because I think you will give your own unique views. And I think the other thing is actually to raise your awareness of the various dispute resolution mechanisms, including mediation, so that, hopefully in future iterations of it, it would also show that in-house counsel have been a major contributor in deciding what form of dispute resolution device should take place. Okay, now I shall move on to another perspective. I'm very happy to have Sean Leong here. Sean will give an external counsel's perspective to mediation. Sean is an experienced international arbitration litigation lawyer. He's represented many clients in cases. Sean, you're also a mediator too, have you? So he wears it from both hats, but I'm gonna pick his counsel hat today. No slides for this one. We're just gonna have a conversation with Sean. I invite you into this conversation, just keeping an eye on time. But maybe to start the ball rolling, Sean, thank you for being here. You've seen many clients, you've dealt with many disputes. What are clients' perceptions to mediation? Are there particular concerns, questions that almost invariably sort of like come up?
Thanks a lot, Anthony. I think the most common misperception is that mediation is a fairly relaxed process. Let's not take it that seriously. Let's just give it a go and try and see how it goes, right? But as counsel, I think it is important for us to help clients understand that you've got to take this process with utmost seriousness, because it's almost one last genuine opportunity to reach a self-determined outcome, before you lose control of the process to the rules of the game, so to speak. Because once you escalate your dispute further, be it court litigation or arbitration, you got to play by the rules of those games, right? Those processes. And so mediation is one last opportunity, I would say, to take a real hard look at your case, to take an honest assessment at your options, and have a proper understanding of where you go from here, right? Because if you don't solve it now in a self-determined outcome with the counterparty, you might reach the point of no return in some cases. For example, if we are looking at open court litigation, once the cat is out of the bag, where our friends from the media will report on the case, there would be a lot of optical and reputational considerations that is out of your control. And I think the final point in this particular regard is that if you place your dispute before a judge or an arbitrator, the judge or arbitrator can only decide based on the rules of evidence and can only determine, who is right or wrong, as Bernard said, can only determine liability. You can't necessarily solve the problem that you have, right? Sometimes even if you have recourse from those processes. Just very quickly, the other common misperception, is that if I offer to mediate, I'm showing weakness. I think the mindset has got to change, right? In the older days, people refer to mediation as an alternative process, alternative DR process. But I think the mindset has got to shift. Mediation, in many ways, invariably must be the first instance consideration for certain kinds of disputes, right? For a lot of commercial disputes, I would say. And that policy, you would say, is already found impliedly in the Singapore Rules of Court, for example, which mandates that before you formally sue somebody or a party, you have to consider amicable resolution. right? So I think there's a bit of education required on clients' part that this is that old mindset is no longer true, and obviously with the advent and the progress made by the SIMC, since its launch 10 years ago, together with the launch of the Singapore Convention on Mediation, I think there's a lot of emphasis placed on mediation now. So from a disputes perspective, I think clients need to understand that mediation is an acceptable way to resolve disputes. It's not about losing face, right? But if we are looking into that losing face factor, I would say two things. First thing is actually in the realm of mind games, you don't lose much by letting your counterparty believe that they have a stronger case than you, right? Because you make them a bit complacent and you enter into the first stage of engagement with that mindset. That could be a strategic advantage. The second strategic point I would say is that we find that in mediation, through engagement with the counterparty directly or via the mediator's assistance, they tend to become an intel gathering exercise as well, right? So there's a bit of a strategic impetus in that regard.
Well, that works for both sides as well.
That's right.
What about situations when the other side refuses, right? I mean, is it a consensual thing? I mean, is that also an impediment that you have to face? How do you advise clients when the other side seems reluctant to mediate?
I think first of all, you have to see if there's a precondition dispute resolution clause to mediate, right? So it is quite common now for there to be a multi-tiered dispute resolution provision which sets mediation or at least some form of amicable resolution as a precondition. Secondly, if you're looking at Singapore court litigation, we've already mentioned that there is it is a necessary process, I beg your pardon, to consider amicable resolution. But if there is an absence of those mechanisms, I think the council would take the view that just because the counterparty refused to mediate at this instance, it doesn't mean it's a closed door forever. Through the process of an arbitration, through the process of a court litigation, especially I think from our observation, after the disclosure stage, where evidence is discovered in that process, that would sometimes be a key opportunity to return to mediation as well.
Yeah, it's interesting you said that, because there was once a party to a mediation, not as mediator but as a party, and we suggested mediation at the outset. There was no mediation clause, and that was thrown out very quickly. It went on, two sets of lawyers, £200,000 later, they suddenly said, look, let's mediate it, and we mediated that within a day. So yeah, there is a question of timing. What are your views on this, Sean? I mean, in terms of having mediation clauses inside, I mean, there have been sometimes mixed views. There's some who'd say, well, let's not have a mediation clause inside because sometimes it's too premature. I'd rather let this thing go to fruition. But now with these rule changes and all that, wouldn't it be a greater impetus for parties to seriously consider having mediation clauses there? Because actually sooner or later, more likely than not, parties will be required to sort of like mediate and talk to each other. What's your views on that?
I think it is good to have a mediation clause because it forces both the client and the lawyers to really assess their options in a sense that even if you don't have a mediation clause, you need to do that exercise in one form or another anyway. But to have a mediation clause means you take it one step further in terms of seriousness, right? So I feel like it is a very natural step to take in terms of any dispute resolution process anyway.
Yeah, I think, to just draw that analogy back to the experiences I had of that, I tried to mediate, but then, £250,000 later, we successfully mediated that in a day. I think that was the case where we were not direct parties. We were suing sort of like, as under third party rights. So we couldn't have looked back and said we wish we had a mediation clause. But in many cases where if you had a mediation clause, I think we would have saved £250,000. Because it was very obvious from both sides when it started that this was one of those cases that would probably be split 50-50 because of the nature of the legal dispute. And that was exactly how it was split. That's how we saw it. So it's paying that price because we didn't have a clause. What about preparing your clients for a mediation? How is that different from preparing them for a trial?
I think for clients, it's important to help them understand that there will be a time to fight, there will be a time to be aggressive, but now is the time to have a problem-solving mindset. Right? Do you want to hang on to your emotions and ego, or do you want to, move forward genuinely to try to resolve this? Right? So I think the mindset is very important. I think the other important thing to brief clients on is to have that agility of mindset, which means that whoever is there with you at the mediation must have that authority to make decisions on the fly, or at least reach the powers that be who can make decisions across, perhaps very late at night or what have you. Because in a court or arbitration process, you have at least 18 months on average to discover evidence, to test the other counterparties' cases. But the entire process is packed within a day, where before dinner or after dinner, someone could just say, actually, you know what, I'm going to show you my evidence. I'm going to disclose my evidence, and you might just have to make a commercial decision right on the spot. So I think you have to be prepared for any curveballs or any unforeseen developments in your understanding of the case across the course of mediation.
And I mean, you've gone through many mediations, many cases. Can you share your experiences of counsel's role in a mediation? What are some of the examples where you thought counsel had helped in the settlement process, or the process towards settlement, or not, and when have they hindered?
I think,
and maybe something about what in your view clients should be looking out for.
I think for counsel, the most important thing is to let go of your pedantic sense of the law, right, and start seeing things more commercially. I think you would assist your client and the mediator if you actually start considering real commercial options, right, that goes beyond that zero-sum game in terms of what the law would say sometimes, right. I shared a few weeks ago at the Hong Kong Conference on Climate Change and International Trade Law, organized by UNCITRAL, the illustration of the Eco Oro against Colombia case. Eco Oro, I mean, whatever I say is public anyway. Eco Oro is a oil and gas giant. They have a license to mine metal and gold deposits in Colombia. Colombia decided one day to protect its nature reserves called the Santaban Highland region, with a natural ability to renew its water resources internally. So they decided that this should be protected land. Colombia decided that, and they revoked the gold mining license. So Eco Oro sued Colombia. Eco Oro is a Canadian company. So they sued in international arbitration based on a treaty between Canada and Colombia. There was an international arbitral tribunal which decided the case, and there was a provision in the treaty between Canada and Colombia which says that Colombia has the right to take any measures to protect its environment. But the arbitral tribunal says that, well, there isn't any language to say, even though there's a right to protect the environment, Colombia doesn't have to compensate damages, right? So the arbitral tribunal found that Colombia has to pay damages to Eco Oro. Colombia invited the Canadian government to make submissions, and Canada itself said, our dear friend Colombia has the right to protect its environment, right? So you have two countries saying they want to protect the environment, and still the arbitral tribunal says no. So a lot of commentators have queried, did the arbitral tribunal come to the right decision? And this is what I say. I say it is not the question whether the arbitral tribunal came to the right decision. It is that the arbitral tribunal had no choice but to decide in a binary way. If that case had been mediated, council might think of a solution, for example, a 5-year transition plan for Colombia to give Eco-Oro an alternative site where Eco-Oro will transit, their mining to a different part of Colombia, subsidized by the Colombian government, which would be less expensive than the damages payable. And after Eco-Oro starts making profit, to dedicate a certain percentage of their profit to pay back to the Colombia government for sustainability initiatives. And that's something that, to land on Senior Counsel George Lim's mantra, turning a dispute into a deal, right, which is a very powerful tool that parties can come together in mediation to do. And lawyers have a key role to play in proposing those commercial solutions. See, something that a judge cannot decide, an arbitrator cannot decide. What they can decide is who is right or wrong, who must pay up or not, you see. So I think the defining role for counsel is to think out of the box, have a very commercial role and commercial mindset in trying to solve the problem.
So that's also an interesting takeaway for all of us as in-house counsel, because as you sort of like seek your legal team to defend or prosecute a case, if you have half a mind on making a deal, what kind of lawyer do you want in that team? No doubt you may want to have somebody who's very skilled and maybe tenacious dispute resolution person, but maybe they also need somebody who's got a knowledge of the field, to be able to sort of like stitch together deals if the opportunity takes place. So these are things for us as in-house counsel to consider when we have a dispute. I think Sean raises some very interesting points, right? Actually, depending on who you put on the team, you can't blame the arbitrator for a mistake because he gave the answer that he's been asked to give, right? But that might not be just. Whereas if one negotiated this, one could not resolve it by negotiation, one had a mediator to sort of like bring all these different interests together, you can actually cobble out a solution which is actually helpful to all the parties and all the stakeholders. I'm going to now turn to cost. It's hard to really answer this question, what's the cost of a mediation, because it depends on the mediator and all that, but maybe as a perspective, right? When you look at the whole process of litigation, right? If let's say you take a case from inception all the way to judgment, let's not even talk about an appeal, right? And you compare the amount that you spend on mediation, ballpark, right? What sort of costs, in your experience, what percentage of cost would that be against the overall bill, if you know what I'm saying?
I think typically it depends on the complexity of the case, right? But I would say that no matter how complex your case is, if you are comparing mediation with, and I'm talking about cross-border mediation with, international arbitration, international dispute resolution, I beg your pardon, international litigation, mediation is definitely the least costly aspect, right? And by a far margin, it's the cheapest process, to be honest. You are also not looking at adverse costs, right? Because in court litigation, there's only one winner, right? And so is the case for arbitration. And the unsuccessful party has to pay adverse costs, right? That has to be factored in as well. So I think it's a no-brainer that mediation would be the most cost-effective way to resolve a matter, if possible to do so. I would also conclude by saying that I can personally testify that to my own personal knowledge, I know of no other international mediation center that is more value for money and cost-effective than the SIMC. So that's my conclusion as well.
That was unscripted.
No, but actually, it's very happy to see Bennett having a very happy face. But we will come to SIMC later. There are reasons for that. It's not just for anything else. It's our reason to be is to help facilitate all these kinds of opportunities for people to reconcile, make peace, move on. So that there's a reason for our being. I'm going to shift now to William. William is the general counsel at Samsung. For him to give us a user's perspective of mediation, I think I can report that William himself has been involved in mediation as a party, and so therefore can give some first-hand experiences and stories to share with us. So, William, really, for you, what are your experiences as an end-user perspective?
Thank you, Anthony. It's a pleasure to be here and share some experiences with the group. And I'm in the in-house counsel role, so I'm actually one of you. On balance, our experience with using mediation as a dispute resolution method has been positive. As Anthony shared, we have been a user, we use SIMC and other institutions for mediation. I want to be mindful that mediation should be confidential, but I think it's okay for me to share some anonymous case stories and just touch on the aspects about the mediation process and how it looks for us. But I'm going to start by talking about a case of ours where actually we did use mediation. So before that, maybe I should give a very quick background on our company. We are international contractor, so we are doing construction projects globally. So with construction projects, usually we have our fair share of disputes. It's almost unheard of for you to do a construction project without a dispute. So we tend to have disputes. So it was 2018. We had a case. It was a plant project. So there were some disputes about equipment failure, scope of work, and so on. And there was actually a mediation clause in the contract. But the other side, which is a contractor, didn't want to go for mediation. They actually went for neutral evaluation. And it's a non-binding neutral evaluation. So there were some technical issues involved. We did a 2-day neutral evaluation. The evaluator was a very respected expert in this kind of specialized contract disputes. He went away. 2 months later, he asked for an extension, and 2 months later, he gave us a neutral evaluation. It turns out the neutral evaluation findings were not acceptable to either party. So we missed an opportunity to dispose of the matter early, and in the end, the matter actually went to arbitration. It was only resolved 4 years later. So this is like a counterexample of not using mediation. Next, I'm going to share about our experience with mediation, which is actually positive. I'll share two stories. One involved a mediation where arbitration has already commenced. Again, it's a construction dispute. We are about a month away to the evidential hearings. Then parties obviously have seen each other's arguments, submissions, and almost all the evidence that there will be. And the other side, which is the claimant side, actually proposed mediation. So we did a mediation in one of the institutions here. There was a 1-day mediation. There was no settlement. But actually, we didn't walk away from the mediation dispirited. Because I noticed something at the end of the mediation session. Our commercial people actually walked over to the other side and and shook the hands of the other side. I must give recognition to the very skillful mediator who was very facilitative, who was really trying to manage the two parties' perspective, which at the start of the day was diverging. But I would say at the end of the day, we were narrowing it down. And parties sort of actually left that session. They were probably not ready to sign a settlement agreement, but they went away still thinking about how to resolve it, other than going through the arbitration. And I want to share that during the mediation, what the parties actually raised and sort of discussed is cost, the likely cost that will be incurred. I think that's something that Sean pointed out. And fortunately, about a week before we actually go to the evidential hearing, it was scheduled for a 10-day hearing. We actually meet again, and the parties signed a settlement agreement. And nobody suffered any adverse cost on it. So that was a positive case study. Another case was more recent, and this one we did a mediation at SIMC. This again is a construction disputes. It's actually about completed projects. There were allegations of defects and so on. The complexity here is it is an 8-party mediation. 8 parties. And here I would like to commend SIMC, the institution, for being very facilitating. Because 8 parties, you can imagine, that means actually there were 8 parties and 7 sets of lawyers. Because 2 of the parties actually are represented by the same lawyer. So when we were actually, okay, let me backtrack. There was a court suit. There was already a court litigation, and as Sean pointed out, it is now mandatory, right, to go for, to at least attempt amicable settlement. So the court directed parties to attempt mediation, and parties duly went for mediation. But when parties go for mediation, signing an agreement to mediate is not the same as having the will to mediate. So even getting the parties to sign the agreement to mediate was a bit difficult. Took some time, and that's where we appreciated SIMC's efforts. A particular registrar was very helpful in coordinating the parties signing the agreement. And I remember this registrar also proposed to some of the parties. So there are 5 contractors among the 8 parties. Because the contractors' interests are more or less aligned, the SIMC registrar actually proposed, why don't you share some cost for rooms? So that was, well, maybe we should have thought of it, but it was good that the institution thought of that, how to save costs for the parties. So that is an example of the flexibility in the procedures and the processes. But going back to the subject matter of the mediation and the outcome, we started on 10 o'clock in the morning. I think it's on Wednesday or Thursday. Because there are 8 parties, the first thing some of us checked with the mediator is, are you okay if we maybe take a bit more time after dinner to conclude? Not that issues are complex, it's just that when you're dealing 8 parties, we're not confident we can finish it in one day. But as it turns out, we signed the mediation agreement at 4 a.m. the next morning. But it's still good. And our experience with mediation is it mirrors the SIDRA survey. It is still speedy, and it's still very cost effective.
So when we say one day, we we literally mean 24 hours. That was not the record. The record was from 9:30 until the next morning 9 a.m. Okay, but it's a good sign. When parties are prepared to go through the night, it means that they are getting close, and they feel that there's a chance for settlement. Those that end very early, like 3 p.m., you know there's no hope that they're going to settle. So we have a staff on standby, on standby throughout the night with them to make sure that anything that needs to get printed is printed, and make sure that the settlement agreement is printed out and everybody signs off, and then he or she then closes up. So everybody is happy. And the beauty of mediation, like I say, it's like you don't see this in arbitration. You see mediations where after the mediation is over, the parties shake hands. In one case, they even went out for drinks with the mediator and took photographs. You're not going to see that in arbitration or litigation.
William, I'm not going to dwell on the question of cost again, but maybe, maybe share with the audience, right? I mean, how did you sort of like get your management? How did you bring the mediation and introduce the mediation discussion to your management, to your colleagues? How did you bring them on board? Or did you have to bring them on board? What's your experience of, working with your management when there's a dispute that arises?
You do have to sell sometimes. Do a selling job internally, right? To your management, your commercial people. The value of using mediation as an option. And I don't know whether the audience here, who I suppose are mainly in-house counsel, share my experience. But a lot of time, commercial people come to you, not in a frame of mind ready for mediation. I think one audience, Fulian, was mentioning about sometimes in professional negligence cases, there's this factor of ego and so on. Now for construction engineers, I mean, if there are construction disputes, contractor disputes, performance issues, they are going to be very defensive because nobody wants to say, oh, I didn't do engineering as well as I was expected to do. So you get very defensive parties that come to us. But for us, the in-house counsel, I think our contribution is not limited to just, okay, I heard from you, I understand your case, let me give you my view on the legal merits. It should not just stop there. I believe the in-house counsel are agents of influence. So we go beyond just looking at the legal case. One of the questions that I find myself asking my commercial people when they come to me about this is, have you considered mediation? And if no, what are the reasons for not doing mediation? For me, this for me to gauge how ready they are for mediation, whether they have the will, the intention. It's frankly easy to get your commercial people to turn up for a mediation session. But if they're just turning up, going through the motion, in their head, they're saying, nothing comes out of this, it's not effective. Frankly, you're just prolonging the dispute. We do work a lot into how to convince internal stakeholders about mediation, about the value of mediation. I'd like to share with you an example. I once had a dispute. It's a local project, and I went to site. We were preparing to have this is ad hoc mediation. There's no institution involved. We're just going to have a meeting, a discussion with the other side. There's a high-ranking project director who met me at the end. It's our own internal meeting, and he made this statement, something to this effect. William, I believe mediation, if I don't get a settlement in the first 5 minutes, it's not going to be effective. So when I heard that, I wasn't actually discouraged, but I was just trying to listening into what's behind those words, that statement. Actually, what he's trying to tell me, I think, is that if I put myself in his shoes and look at things through his eyes, he's actually just burdened with 1,000 other things on his project. So this mediation has a dispute here, but he wants to spend the minimum possible time on it. So recognizing that, I told him, okay, why don't we do this? Surprise, surprise, is there Mr. Kim? I told Mr. Kim, why don't we do this? Let the legal team and the site team talk to the other side. But if we come to a certain decision, or we need you to make a certain decision, you join us for just 5 minutes. But of course, I would have done my homework before proposing a conciliatory mediation. I know that that project needs to do certain things, needs to have certain work done by a certain date. Then the rest of the disputes are monetary in nature. So I told Mr. Kim, if I can achieve an agreement on when to get those works done, then for the rest, a range of figure as a settlement. Is that good enough for you? It is good enough. And we managed to actually settle that at site. How about it? So that is something that I think that is the value of the in-house counsel that is not thinking in binary terms. And this is something that I always tell my team also. Think of the business case before the legal case. It's very easy for in-house counsel to just confine themselves to, okay, I just deal with the legal points. I leave the commercial things to you. But I want the team to think about the business case, because that's the language that your commercial people speak.
Thank you, William. Actually, I've always been fascinated. Sometimes when I was talking to my team, and I interview lawyers, right? So I want to come from external and join the internal because I want to be in the middle of a commercial organization, and be part of making commercial decisions. And I think part of it is making these types of commercial decisions, and I think that's where, even for many of our own in-house lawyers, it is an area that we need to continue to guide them and help them towards making these commercial recommendations, participating in the commercial discussions. Thank you, William. I think there's a lot of very interesting elements. I'm now also, in the interest of time, turning to Francis to give a mediator's perspective. I'm going to just hand over the floor. You know what the questions I would like to ask you. How do you prepare? What are the ingredients of a successful mediation? What are some of the common obstacles you see? Just take it away, share your stories.
Thanks, Anthony. I'm a lawyer, an arbitrator, and a mediator. 34 years in the field. People ask me, why do you want to be a mediator? And I tell them that it's the most satisfying part of my practice. And here is the reason why. In a mediation, the parties come to you at an impasse. The classic situation is an arbitration has been filed, or litigation has been started, or just communications have broken down. And as a mediator, I have to use my training in the process, training in the people skills, training in the problem solving skills to bring these parties together. Very often, these parties and the external counsel may not be the most cooperative parties, or may not be in the most cooperative mindset. So Anthony was asking me, what is the biggest problem I face as a mediator? I'll say it's counsel, external counsel, and the clients who come to the mediation with an adversarial mindset. This makes it challenging for the mediation because from the very start, we're having to manage the emotion, manage the egos, dissect the legal dispute, and very often that is just scratching the surface. Because the legal dispute is a symptom of the underlying unmet needs, unmet interests of the parties themselves. So they begin a lawsuit and claim damages to be assessed. But what does that damages represent? Maybe it was a failed project. Maybe it was a project that damaged their reputation. Maybe it was a relationship where communication has broken down, or where trust has broken down because they say, I want information but you're not sharing it with me. And inevitably, when you're in a dispute situation, the lawyers will tell you don't talk to each other. Everything that you say can and will be used against you. So herein lies the problem. In a mediation, what makes it so special is because, as Bennett said, it's a safe space. There's confidentiality. Parties have come to this mediation voluntarily, and they are investing their time and their day to solve the problem. The mediator's role is to create and hold that safe space where parties are able to share their perspectives. Then we summarize so that the parties can hear from a neutral voice what the needs and the interests are. And then we start unpacking the emotions and bringing the parties closer together. You've just heard from Sean, the external counsel perspective, how when they switch from an adversarial mindset to a collaborative mindset, magic happens. We've heard from William, who says, as in-house counsel, you need to not just mediate the dispute that's happened, but to have a commercial business perspective, a problem-solving mindset that is, say, we have a problem now. Yes, we can go to court and spend lots of money and time, or we can find a way to solve the problem and move forward, and perhaps preserve relationships. So I took Anthony's hint about in the interest of time, because I think he wants to leave time for Q&A as well. So I will simply leave you with this thought. As you all looked at Miriam's slides earlier, in-house counsel recommending mediation was at 29%, if I recall. It was the external counsel that was recommending mediation, clients recommending the mediation, but why not in-house counsel? You all are the gatekeepers of your organizations. When I go into a mediation, as mediator, I don't necessarily look at the counsel. I look at the client. And very often when I ask the counsel, what does your client really want? They'll say, wait, I go and take instructions. And invariably, the instructions are from a GC. So you know what your client or what your company needs, the interests, the underlying relationships. You know what you may want to craft as a future. So whatever problem that has happened, I ask this question. I know you are a busy person. You want to make the pain go away. What does a future look like to you with this problem solved and the relationships fixed? What would you like it to be? And ask it of the other party as well. And then we work in the mediation session to bring parties closer together. So that's the job of the mediator. It's a hard job. It's a satisfying job. It will be made very much easier with GCs who recommend mediation and come with this problem-solving mindset. Counsels like Sean, they will come with the problem-solving mindset alongside their client And it leaves me to say that working with SIMC in institutional mediation is probably the best way to go. So recently I mediated in an SIMC matter where there were 5 parties in the dispute. Alright, we couldn't settle the dispute because 5 parties had different interests, but as Bennett highlighted earlier, we were able to narrow the disputes so that parties understood the issues that they needed to address as they move forward. And as I understood, because I caught up with one of the council last week, they tell me that they are still talking, alright? When previously, before the mediation, there was all suspicion, but then now parties are back to a constructive working relationship. So that's the magic of mediation. I'll leave it to you all to help increase that magic and make it work for yourself. And don't forget Mariam's survey, please. The more people we have knowing about mediation and participating in mediation will help make the magic work better. Thank you. Over to you, Anthony.
Thank you. I'm sending this back to Bennett to say a few things about SIMC. Because of time, we may not have time to sort of like go through a Q&A, but happy for you to approach us directly after this, and I will wrap up with some points. Bennett.
Okay, just to introduce SIMC to those who may not be familiar with it, we are just 10 years old. This is a project that was launched together with the Minister and our Chairman, George Lim, and Sundaresh Menon of CJ. This is our case management statistic since we were started in 2014. We don't have that many cases. I mean, compared to even the Chinese cities mediation, they are talking about tens of thousands. We are only like 480 cases to date since over the 10 years. But our dispute values are very high. It's not uncommon for us to get disputes over 50 million US and even 100 over million. Our biggest case to date is 8 million US dispute. So average settlement rate, it kind of fluctuates between around the 70% figure, sometimes higher, sometimes lower. Origin of parties, I mean, we're very proud of this because we see people from all over the world coming to mediate SIMC from as far as the Americas. So we have like, every year we are adding new jurisdictions. The kind of dispute category is basically everything under the sun. I mean, this is just a summary. And of course, the latest, as I said, are crypto assets. Mixed mode ADR, I think some of you are familiar with this, where we have this protocols with SIC and SICC, where arbitration is immediately stayed after it started and sent to SIMC for mediation over 8 weeks. If it is successful, then the settlement agreement can be sent back to SIC or SICC to be recorded as an arbitral award in the case of SIC, and in the case of SICC, recorded as an order of court and therefore enforceable as such. We also have a protocol of the Singapore Shenzhen Court of International Arbitration, where they are prepared to register our mediation settlement agreements as arbitral awards and enforceable throughout China. So this, as you're aware, is the Singapore Convention. This is a signing ceremony, just pictures, and this is the map as it is right now. The number of countries that have signed or have ratified. Those in red are those where the convention is now fully effective. Now this is interesting because as we're addressing in-house councils, this was an event that we held during our 10th anniversary, where we got some multinationals and associations to pledge their support for mediation. Okay, so you see the bottom row where they are all signing in public. Okay, and these are the MNCs that were represented at the signing ceremony. You see that the 4 biggest conglomerates in India are there. We have Huawei, we have Microsoft, we have most of the big names have Johnson, Jones Lang, Luton. So quite a few big names there. Meta, all have committed themselves to promote and support mediation. Now we conduct training as part of our job because we want to spread the message of mediation. And so we have specialist mediators workshop where we give a 2-day training on mediation skills. We have a mediator accreditation workshop where we are what we call a qualifying assessment provider. In other words, CME has given SIMC the authority to accredit and test and kind of meet their standards and get them accredited with CME. Mediation advocacy program, you realize that sometimes lawyers can be a problem. They are the obstacle in the mediation and they have not prepared their clients properly. So the mediation advocacy program is really to prepare lawyers when they are getting their clients ready for mediation, and also when they are in the mediation, how they should be facilitating the mediation. And then of course we have customized corporate training. We are doing some for in-house, just one company alone to teach them about mediation. We have conducted training over 15 countries, trained more than 600 mediation professionals from more than 20 countries. 80% of these trainees are ordinary residents outside of Singapore, so we are spreading the message worldwide. So there are tentative training destinations for this year here. In last year we went as far as Costa Rica and Jamaica. This year we are planning to go to Peru. And now this is a question I always get. How much does it cost to mediate? Okay, I can only speak for SIMC. And the question is, why don't we have a table of mediation fee rates? I can tell you very simply, it's because whatever table we put out there is going to be full of caveats. Because there are a lot of factors that contribute to the cost of mediation. So what you see is not really going to be accurate, even if I give you a table. Now, what is it dependent on? Depends on, of course, the number of days of mediation required. Like I said, most of the time it's 1 day, but in certain cases, because the parties are flying in from overseas, they may want to have 2 days, 3 days, or maybe the matter is complex enough to justify more than 2 days, 1 day. Number of parties in the mediation. The more parties there are, the more complex it gets, the more work for the mediator, and of course the mediators will charge differently. And of course, the more parties to the mediation, you need more rooms for the private sessions. The mode of mediation, is it going to be in person, which means rooms are involved, or is it going to be online, in which case you may save on the room rentals. The time of mediation. Now, time of mediation is important because some mediators do charge. I mean, obviously, right, you wanted to mediate in the middle of the night. So some people think that online is always cheaper, not necessarily, because if it's in the middle of the night, it can actually cost quite a bit. The mediators are charging a premium. The venue of the mediation, obviously, is a factor. The number of persons attending the mediation, this affects the size of the rooms that we need to book. So again, it's an unknown factor. Choice of mediator, a very big factor, okay? The mediators have different fee rates, and not only different fee rates, they have different fee models, okay? In other words, some mediators charge for certain things and some don't. So it really varies quite a bit depending on which mediator you choose. And that is the biggest bulk of the cost, okay? The mediator's fee. And finally, the value in dispute and the complexity of the dispute. Some mediators do add a premium if the matter is complex or if the value of the dispute is high, as an indication of the complexity, right? But rest assured, like I say, SIMC is a not-for-profit institution. We are not here to clock record revenues. We are here to promote mediation. We try not to turn away any parties that wish to mediate SIMC purely on account of cost. So we try our best to meet expectations of the parties cost-wise. So like as William said, we even try to find ways to save money for the parties when we can. So that's all I have. Yeah, that's all I have.
Thank you, Bennett. Is there a question?
Yeah, just a very quick one. Maybe for either William or Francis, how important it is in choosing your delegation to the mediation to have at least someone who's not directly involved in that dispute, so as to remove the, to manage the emotive and ego kind of factor. Obviously you need a decision maker, you need someone who knows a bit about the dispute, but I would think you want to have someone who is not directly involved into the day-to-day project, for example, that they are able to remove themselves and have that positive mindset towards settlement. How important is that, Francis or William?
Francis, you want to take it first?
As a guideline, I would say anyone with a vested interest in your party or client's story should be involved. The second aspect is that whoever is coming for the mediation needs to have the authority to make a decision. So I give you a classic example which I encountered. US company against a Asian company, and the US party was sending their line manager because that line manager knew all the information. But he may or may not have authority because he has a limited mandate. Then the Asian party sends their managing director, all right? And the managing director was very offended that this line manager came because he felt disrespected. So I give this example because you can see the complexities. Obviously there's culture, there's emotion, but just on the part of who comes to the mediation, not just a person who knows the facts, but also a person who can have the authority. It may be that the person with the authority is full of emotional baggage, but don't worry, that's the mediator's problem to sort out. Okay? Thank you.
I hope that answers the question.
Yeah.
Just spare me 5 minutes and we're done. I thought, it's a very interesting panel discussion. I bring us back to the question, why it's a must in today's, why mediation is a must in today's general counsel's toolbox. And I thought I'd just pull all the strands together. Hopefully it will be something that's helpful to all of you. And I would offer you 6 C's as reasons and 1 C for a call to action. I think the first reason why it ought to be in your toolbox is just simply the complexity of disputes that you see nowadays. I think most of this SCCA Congress, you talked about technology advances, ESG, geopolitical risks. All these risks are amplified when they go cross-border. And when you bring it cross-border with all these risks, there's uncertainty in the result of any litigation and arbitration. So I think it is something which most companies would want to keep the decisions within their own hands. And if possible, create a deal out of the dispute. So bear in mind that, with all these complexities, do you really feel as general counsel and trusted strategic legal advisor to say, let's leave it to a judge to decide these issues? Maybe there's certain things which a judge ought to decide, but I think you should take a lot of steps to make sure that that issue you want to put before the judge or the tribunal should be very much targeted and thought through. Second issue is very evident from our conversations today. You must know this because it's cost and time savings. These are actually one of the very few opportunities where general counsel can show empirical evidence how they've saved money for their company. You can actually look and say, well, I've done this through mediation, it's cost us X dollars. If we've gone through this all the way to the full halt, it would have cost us 10X dollars. It is because of our knowledge, our connections, our ability to lead a mediation that's allowed the company to sort of like save this amount of money, leaving aside management time and reputational risks. It's also very convenient. Everybody, when you have a dispute, very kanchiong, you either fight immediately, sue immediately, or you want to talk immediately. I hope we've demonstrated that we can probably pull a mediation together very quickly. Probably most time is going to be spent trying to agree on who the mediator is. Also remember that is another C is complementary to other dispute resolution platforms. Don't think that this is an alternative. This is all complementary. Everything out there that's open for you to decide your rights are still there. But if this device allows you to sort of like consider interest as well. Another C is actually for you to control your external lawyers. My own experience is that when we have a dispute, we just bring it to a dispute lawyer and say, nah, you go and fight this case for me. I think we need, as in-house lawyers, to do better than that. I think we need to be able to sort of like decide what lawyers, how the team should be constituted. They are experts at advising us on what our rights and obligations are. We translate that to the company, but we also are the experts in knowing what the interests of the company are and to translate that to the lawyers. We have a very important role in this. It's a role that allows you to control the lawyers, manage your costs, manage the outcomes better, and be very involved in what is very often one of the most stressful part of a corporate's existence is actually to deal with disputes in many instances. I think it also consolidates your position as a trusted strategic partner. That's another theme of today, of this in-house congress. You are very often the only adults in the room when everybody is angry and wants to tear someone else down. You know, the other project engineer is really stupid and incompetent. You know, the CEO is a crook. Everybody's head sort of like runs ahead of themselves. You're the one who's going to have to tell them, well, are you prepared to be cross-examined by so and so? You may have to sort of like do that. You are also the ones who know the massive amounts of restructurings that might happen in your company. Your star witnesses, your project engineers, they may not be around in 2 years' time to give evidence. I think that's also a reality check that you as in-house lawyers need to be able to think ahead, horizon scan the risk, and tell your organizations. It might look all very cheerful now, but when that time happens, do you have the sticks and the stones to throw back? That's also a responsibility that you have. So it consolidates your position. And finally, the call to action is, if you think that mediation is something that can help you, consider putting clauses in your contracts. That's going to help you plenty when a dispute happens. And the first question that you then have in absent a clause is, do I mediate? Should I mediate? What should I do? If you had that clause, you just go straight through into it. With those C's, I'd like to conclude. The final C is to conclude, to thank my panelists for joining us. Thank you all for staying with us through this period. If there are any questions, please feel free to ask us, or you can sort of like reach us in our websites and all that. We'll be very happy to discuss things with you and help you whenever you need that help. Thank you very much. I think it's coffee time. I don't know whether they've got the beer out right now for those who want it, but